Okay, folks, let's get started. This is a criminal procedure topic, police screening, and it's linked to Chapter 3, Part A of the Miller and Wright text, Criminal Procedures, Prosecution and Adjudication. Now, we've reached a point in the process where the police have more or less completed their investigation. From here on, there will be various moments when some government actor or some public representative, like a juror, will decide whether to go forward with the case. Lots of people can stop a case. Think of the early screening decisions like a fisherman's decision to catch and release. Did the police here catch a big enough fish? Is there enough evidence to support the catch? Is a criminal sanction important enough here to justify the public cost, the personal impact to the defendant of going forward with criminal charges here? Now, this kind of measuring the fish question happens all the time with individual police officers out in the field. They are all the time noticing something that probably is a violation of the criminal law, but they just decide it's smarter, it's better for everybody if they walk away. Maybe they warn the person, talk to the person, try to change it so that it won't happen next time, but they don't end up invoking the criminal process. So it happens at the individual level all the time. It also happens at the departmental level. An individual officer might go through with an arrest, want to go forward with a charge, but ultimately the department as a whole might decide we're not going to take this fish back to the docks. We're throwing it out of the boat. So before they ever decide to send it to the prosecutor, the police department as a whole will sometimes screen out charges. Now, these police department screening habits look different as you go from place to place. You've read a couple of examples. For instance, in Houston, the basic strategy is consultation between a police officer and a prosecuting attorney. In fact, Part 1 of these guidelines talk about consultation with an ADA. The vision is of a prosecutor who might be physically located within the police department, certainly very accessible, whether physically or not, within the police department, and it's an ongoing conversation. These rules don't lay out substantive criteria. How strong does the evidence have to be? It's just a matter of talk to the ADA. And as long as you've done that, then the Houston Police Department is willing to go forward with sending the case over. Now, the Philadelphia process is a little bit more bureaucratic, and it's more internal. It's more police talking to police. So in this paper-driven process, the police independently fill out the complaint fact sheet along with an arrest report, a hearing sheet, investigators' aid to interview, investigation report. Notice the policy here is all about what does the file have to have, your checklist for the file. It's not about talk to the right people, it's get the right stuff into the file. Although there are different bureaucratic structures that carry out this police screening function as you go from place to place, there are certain universal themes that run through the police-prosecutor relationship, or I guess we could say universal tensions. They show up in vivid form in the Cochise County showdown. It starts with a letter from relatively newly elected county attorney Ed Reinheimer, who is looking around and saying something weird's going on. The police are filing directly in court, and that's unusual, and I'd like to change that practice. So he writes a letter to Glenn Nichols, the chief of police in Benson, Arizona, within his jurisdiction, one of several police departments within the county. And in this letter, Reinheimer says, I'd like to get prosecutor review of the charges that might be filed, the felony charges that might be filed in court before they go there. No more direct police filing. He gives several reasons for doing that. First of all, he says it will help us coordinate better with the limited grand jury calendar. It'll save court time because we won't be filing cases that ultimately have no chance of going forward. We'll be saving on jail time. We won't have to invest in jail cells holding people who ultimately were not going to go forward with their charges. And he also says that this kind of pre-screening will identify as early as possible the cases that need further investigation. A little bit tricky here to be suggesting that the files aren't coming in just the shape that the prosecutor needs it. So that's why he wants to do it. How does he want to do it? Well, he says, here's a checklist. I want you to go through this. I want you to make this checklist a part of your normal processing of cases, just to make sure that we have, as the prosecutor's office, we have the things that we need to decide very early on before it's filed in court whether this case will go forward. And then he spends the last few paragraphs of the letter anticipating objections. So he says this is not going to add to your officer's workload. It's just going to front load it. This is stuff they'd end up doing anyway, but we want to make sure it gets done before we invoke all the court time involved in a direct filing system. And he says, I've hesitated to ask for this. I've been in office for a few months and I'm just now raising it because, quote, I don't want anyone in the field of law enforcement to perceive the change as being in any way a criticism of law enforcement procedures. And he says, don't worry, they're still really dangerous people, and we're going to do whatever it takes to move very quickly on those. So how did Chief Nichols and his peers take it? Oh, not very well. So you've read some of the reply letter. It starts off by noting that the newspaper had already received a copy of his letter. Wonder who sent that. It can't be good, right, if this kind of letter is showing up in the local newspaper. But then it goes beyond the usual bureaucrat speak and starts talking about prosecutor incompetence. So the reply letter says, we're extremely concerned with the dismissal of cases and your inability to take the case to a grand jury. Also, later in the letter, the police chiefs mentioned that, look, you're talking about a checklist. It's doomed for failure because you already lose our files. This is just one more piece of paper that your office is going to lose. Moving beyond the prosecutor incompetence theme of the reply letter is a very important difference in perspective between the police and the prosecutor. So throughout this letter, the police are focused on the hurdle that they have to clear, and that is probable cause. They keep saying, we've got sufficient probable cause in these cases. What's your problem? As they put it, it's unrealistic to ask for more than probable cause. If you're really dismissing about half of all the cases for, quote, evidentiary requirements beyond those to establish probable cause, then maybe this whole new checklist review idea is just a red herring. It may be that they see the problem is that the county attorney is just using the wrong standard here. You should, like us, be focused on probable cause for filing. That's the legally sufficient standard for filing. Obviously, the prosecutor is not just focused on filing, but they're looking down the road to what they're going to need to clear the next hurdle, which is a conviction. And there they're going to need proof beyond a reasonable doubt. And finally, in a bizarre suggestion in the letter, the police chiefs ask whether the prosecutors are opening up their officers to civil liability when they dismiss charges. And after all, the police chiefs say, our officers have only qualified immunity while you prosecutors enjoy absolute immunity, and you might be opening us up to civil suits when you diss our cases this way. There's another important sort of culture clash theme going on in this letter, and that is that the DA's letter, or the county attorney's letter, is sort of a second guessing of our vigorous efforts to screen before you ever get the case. So in various ways, the letter says, we've already thinned out the arrestees. We already get complaints from the public about the people that we leave out in the field unarrested, undetained. So once we have acted, believe us, they're dangerous. We have already weeded out all the small potatoes cases. The fish we're giving to you are plenty big enough to go to market. And so the police chief's solution here is not to screen out more cases or not to screen them out earlier and more efficiently, but instead to increase the capacity of the system. We're already screening everything that needs to be screened out. What we need is more grand jury time and more guts, they would say, by a prosecutor to go forward with these cases that are well worth it. We've already pre-screened them. And then there's also this theme in the response letter about a general lack of respect that they perceive in Mr. Reinheimer's initial letter to them. So there's one sort of quick line in Reinheimer's letter that says police officers are not lawyers. The police chiefs took that to be quite an insult, and so they reply, well, police officers are not lawyers, and thank goodness for that. They have to act more quickly, their life is on the line, they're risking their lives to serve their communities. We don't, and here's the quote, we don't believe they will sit back and listen to someone who insults their intelligence and minimizes the importance of their duty. it's you could think of this as just one set of clashing personalities, but it is an ongoing diplomatic challenge for prosecutors to emphasize that police bring different strengths and perspectives to this process than the lawyers in the prosecutor's office do, but we're not looking down on that. Everybody has their thing to contribute here. So what's Reinheimer's next move? Well, he does follow the suggestion of the chiefs and call in a consultant with some kind of law enforcement background and credibility. The consultant basically backs Reinheimer and says, yeah, this is weird going on here in Cochise, and you need to have some kind of upfront screening involving the prosecutor's evaluation of the case, no more direct filing. But he also says, the consultant, here are some suggestions for better communication going forward between your organizations. This whole relationship is central to the work of prosecutors and to the work of police chiefs, police administrators. It's a common issue. You see it playing out badly in some places and very well in others. It's playing out badly if pretty regularly the police chief is on television trashing the prosecutor for not carrying forward with our cases that we've pre-screened, using our standard probable cause rather than that later stuff that's not relevant now. It happens more positively, I think, when the interactions don't happen by way of trading media barbs on the television, but instead they're meeting at the local, diner, steakhouse, Western Sizzlin', whatever. They're getting together to talk through cases and how to save money on the process, how to run the jail more efficiently. So if it's a television kind of relationship, not a good sign. If it's a Western Sizzlin' kind of talking it over lunch, that's normally what the prosecutor's after. In the most effective jurisdictions, the prosecutor ends up de facto being the sort of lead crime control officer, but can't lead by command, can't lead by, I order you to do this or that, but leads by some form of persuasion and diplomatic skill. Okay, we'll be talking more about the screening decisions and the various forms it takes when we get together next time. See you then.